the reasonable expectation of privacy problem. The actual holding in Katz was that that Katz had kept the information private as a factual matter, and therefore was protected from government interference. It was Harlan's concurrence in Katz that said, I think it's because there's a reasonable expectation of privacy that society is willing to countenance. And that's where that case has gone all wrong. In the Kelo case, the defendant had kept the information about what was going on inside the house private. As a factual matter, ordinary people using ordinary technologies couldn't tell what was happening inside the house. And Scalia, Law and Order Scalia, said, no, you can't use some crazy whacked device to go and figure out what's happening inside the house because that is unreasonable. And that's a really important thread that may over time come to solve the problem with Katz. But what I really think your question goes to is the Fourth Amendment and the third-party doctrine. That's a series of cases starting with the Bank Secrecy Act, which found that records in the hands of third parties, people couldn't assert Fourth Amendment rights over them. So when banks collected information as required by the federal government and then handed it over to the federal government said, well, you handed the information over to the bank, so you don't have any Fourth Amendment rights in it. We're doing that on a massive scale today compared to the past with our ISPs, with all the service providers that constitute the cloud. I have to say, as an aside, I hate the term cloud computing because it seems to suggest that there's just some big morass that the data goes into, when we should all recognize that it travels over specific networks and it resides in specific databases for whom specific entities are responsible. So I would do away with cloud entirely and let George Carlin, it's sort of like a George Carlin skit. I don't know what happened to it. It's in the cloud. What happened, man? It's not like that.
Eric.
We should have law.
Eric Wenger from Microsoft. 2 quick points. As long as we're talking about the Kelo decision, one of the things that's really interesting about it is that it was built on the technology of the time. The Supreme Court said that because those kinds of devices were not commonly available in the public, the expectation of privacy was reasonable. And so I think actually a lot of the devices that the police were using at the time are much more commonly available. So that sort of points out the problem I think that Jim was identifying, which is that the scale kind of changes over time about what's reasonable, and that's kind of a scary prospect with regard to our Fourth Amendment rights. And coming back to Stephen's point, which is that all this data is being held in the hands of third parties, we're talking about social networking tools here that are generally consensual in the sense that you hopefully are sharing what you intend to share. But even then, there's a backside to what these providers have that can be connected up in interesting new ways, and the government can grab that information using subpoenas or search warrants. And our general counsel, Brad Smith, was in town last week, gave a speech at the Brookings Institution, and there took the position that that there should be Fourth Amendment rights that people should have, and there should be a reform to the Electronic Communications Privacy Act that would clarify the rights that people have with regard to data that they are holding in the hands of third parties. So, hopefully that is a step in the right direction towards alleviating that concern.
So, Jim, I'll let you conclude with this. Is this going to be one of the unique areas where business and advocates actually agree, where we don't want all the data that is now going to be created and wasn't needed before to suddenly be available to the government, and are the advocates and business going to do some deal, or is law enforcement going to bust it up?
It certainly could be. It would be my responsibility to find some reason to disagree with the business community, of course. But I was just going to observe that there is a battle going on now for the definition of privacy, and you hear it a lot from people in the national security community who are trying to redefine privacy, which at heart is about control of personal information, each of us having control over our own information, as hard as that may be. They're seeking a fundamental shift, meaning well, of course, but wrongly, to privacy as an appropriate set of protections around data about you held by the government. You have your privacy because there's a Privacy and Civil Liberties Board. There's no staff on it, right? There's no membership. You have your privacy because there's a DHS Privacy Committee. You have your privacy because we have all these rules around the data we're holding about you. I think that's fundamentally wrong, though they mean well. I honestly say that because they want to use data to secure the country. They're wrong about what privacy is. It's about individuals having control of information about themselves.
Well, let me close with the end of this Scalia story, because what happened recently, and again I mentioned this on Monday night, is I was on a panel, and the panel was Scalia, me, a rabbi, and a lawyer. This is not a joke. This is not three parrots and a monkey were in the bar. This is a true story. We're on this panel, and it's about privacy from Talmud to Bible to history. And, I guess he thought that was interesting, and so he came and he participated, and he had been told nobody had to do prepared speeches. But, speakers get up and you give us the podium and we speak. And so I got up, and in an attempt to curry favor and maybe alter the course of jurisprudence, I brought up the Keynote decision, and I said, Justice Scalia, great champion of privacy, the majority opinion, you stuck up for technology privacy, and that's why we need internet privacy. And I go into my whole rant about how important it is, and the rabbi talks about privacy from the Bible, the lawyer talks about it, and Scalia is looking a little bit annoyed because he had been told no speeches. It was going to be kind of a round table, and now it's his turn. And so he gets up and he says, look, there was no speeches here, but since you all made speeches and I don't have one, I'm going to go down the line. I'm going to tell how each and every one of you is absolutely wrong. Mr. Polonetsky, passionate young man, you have no clue. We have a First Amendment in this country. There is no internet privacy. There should be no internet privacy. You clearly don't. And he goes into this terrible long rant about how they're really hoping to kind of support privacy and kind of encourage him as a privacy advocate. Instead, it led to this terrible rant about there being no internet privacy, and that's his last public record statement on that issue. So I hope I have not, in my online reputation, done great harm to the future of this issue. Here's what we're going to do now. We have a couple-minute break for refreshments, and then at noon we are having lunch, and we're having our keynote presentation from Michael Fertik, CEO of ReputationDefender, who will tell us how he's making a good living helping people keep their reputation safe and what really can be done if you wanted to fix it and you had the right and powerful tools. So thank you to our host and sponsor, Microsoft, for being with us and releasing this research, and for all of you for being here. We'll take a break and have some refreshments, and then sit down, have lunch, and we will be hearing from Michael. So thank you, and thank you to my panelists for your...
Every hearing starts with that. Everybody goes, oh.
I don't know that there's a policy to do that, but there's... I would also use some judgment. I mean, if I'm hiring an intern, and I've seen them with a beer in their hands, I may take that with a grain of salt. I found somebody that had a website with them with devil horns on it and all sorts of stuff that I thought should terrible judgment, and career position. I may be stuck with that person for 30 years. They went right into the don't consider pile. That's just me. I mean, that's... Oh, there's a whole process. Our attorneys, actually, is much more informal. We tend not to hire attorneys at our division's education and outreach. Thank you very much. We do a posting, we get these USA jobs. They're screened by our HR office, but not for really substantive things. And then